lot of folks have been asking us whether businesses and individuals charged with marijuana and THC offenses can still rely on hemp laws for their defense. The answer is not so simple. In many ways, this federal hemp ban would take away a lot of the defenses available using hemp laws. In other ways, you still have some defenses. For the next year, the same defenses that have been available under the 2018 Farm Bill will still be available. A year from now, if the current hemp ban goes into effect as it's currently written, then certain defenses will change. For example, the hemp ban's closing the THCA loophole means you can't claim ignorance just because the amount of Delta 9 in a product was under 0.3%. Now, if you have a high THCA product, that's an illegal product and you're charged with knowledge of that. Another consequence of closing the THCA loophole is that field tests are now going to be considered more reliable. In the past, under the previous law, field tests cannot distinguish between Delta 9 and THCA. Now, under the new law, it doesn't matter whether it's Delta 9 or THCA because both will be subject to that legal limit. Another example of a defense that would no longer be available is the "you got the wrong THC" argument. Now that synthetically derived cannabinoids like Delta 8 THC and THCP will be considered illegal, you can't claim that this is the wrong kind of THC that you've been charged with. The same applies to the 0.4 milligram cap on THC products. It won't matter if your product contains less than 0.3% of Delta 9 THC if it's over that really low milligram cap. For that reason, any evidence of impairment or intoxication from a hemp product will be probative and used against you based on the alleged sale of an intoxicating hemp product that's not allowed. The good news is that not all of the defenses are gone. Individuals and businesses that are charged with marijuana or THC offenses can still rely on some basic hemp laws for their defense. For example, the smell of cannabis alone is still not enough to justify probable cause to stop and search a vehicle. That's because even under this new hemp ban, there will still be products that are legal, but that resemble, smell like, and look like illegal marijuana. Think CBD flower and CBD vapes. The smell looks just like marijuana, but they are indistinguishable unless you have a lab test. Similarly, businesses and individuals can still rely on certificates of analysis showing that the product that they have are compliant. If you have a lab test for your product showing that it's compliant, you have a strong defense of lack of knowledge, even if that product tested over the limit or was otherwise excluded from the definition of hemp. Individuals and businesses in states that are more hemp-friendly can also claim that their state laws should trump the federal ban, which is narrower. The core truth, though, is that even under this ban, there are going to be products that are legal that resemble illegal marijuana and illegal THC, and it takes a lab test to tell the difference. As long as that remains true, folks who are charged with marijuana or THC offenses will be able to rely on hemp laws for their defense. And with an experienced attorney who knows hemp laws, they will be able to overwhelm the prosecution. Our firm has a track record of doing just that. Call us if you need our legal services.